Hi, and welcome to ProfDale's property video number 9. We've been working on future interests, and in this video we're going to cover two additional kinds of future interests, the remainder and the executory interest. Let's briefly review the 5 kinds of future interests that we've covered in the previous video. 3 of them are created in the grantor, namely the possibility of reverter, the right of entry or power of termination, and the reversion. And 2 are created in someone other than the grantor, the ones we're going to cover in this video, the remainder and the executory interest. By the way, when we say grantor, that of course applies to a conveyance by a deed, but we also mean conveyances that are done by a will. A conveyance by a will is called a devise, and the person who grants it is called a devisor or a testator, and those are included as well when we talk about being created in the grantor or someone other than the grantor. In the previous video, we learned how to identify each of the 3 kinds of future interests that's created in a grantor. The possibility of reverter is easy to identify because it always follows a determinable estate, usually a fee simple determinable. Likewise, the right of entry or power of termination always follows an estate on condition subsequent. Almost always, it's a fee simple on condition subsequent. The 3rd kind of future interest created in a grantor is a reversion, and it follows any other type of estate, that is, one that doesn't follow a determinable or condition subsequent estate. In this video, we're going to talk about the remainder and the executory interests, and the question is how to identify each of those 2. Both of them are created in someone other than the grantor. Well, here's the way we tell them apart. There are 4 rules for remainders. If a future interest is created in somebody other than the grantor and it satisfies all 4 of the rules for remainders, then it must be a remainder. If it doesn't satisfy one or more of the rules for remainders, the only other choice is it must be an executory interest. So that's how we tell the 2 apart. So what are the rules for remainders? Well, to be a remainder, a future interest, that is created in someone other than the grantor, has to satisfy these 4 rules. First, it's got to follow a freehold estate, but not a fee simple defeasible estate. As a practical matter, what that boils down to is that remainders virtually always follow life estates. Theoretically, it's possible for a remainder to follow a fee tail estate, but fee tails have been done away with or turned into fee simple in nearly all states today. So as a practical matter, remainders follow life estates. The second rule is that the remainder's got to be created at the same time and by the same instrument that creates the prior life estate. The third rule is that a remainder mustn't have the ability to cut short the prior life estate. It's got to wait patiently until the prior life estate ends naturally by the death of the measuring life. And the 4th rule is there must not be a built-in time gap, one that's certain to occur between the prior life estate and the remainder. In other words, the remainder has got to be at least possibly ready to take immediately at the end of the prior life estate. Let's try applying the rules for remainders to this very simple, almost classic example. O owns the land in fee simple absolute and conveys to A for life, then to B. Obviously, A has a life estate here, but what we want to do is focus on B's interests. So let's examine our logical reasoning one step at a time. First of all, it's clear that B has a future interest. B doesn't get possession of the land until A dies, and that's the classic meaning of a future interest. The possession is deferred until a future date. Second, the future interest is created in B, and B is obviously not the grantor. The grantor was O, and therefore it's got to be either a remainder or an executory interest that B is holding. We can tell which one it is, that is, a remainder or an executory interest, by applying the rules for remainders to see if B's future interest satisfies all of them. So does B's future interest satisfy the 4 rules for remainders? Well, let's do them one at a time. The first rule is that a remainder has to follow a freehold estate but not a fee simple. As a practical matter, that means a life estate, and sure enough, B's future interest follows A's life estate. So that rule is satisfied. The second rule is that the remainder's got to be created at the same time and by the same instrument that created the prior estate. Here, the deed or will from O said to A for life, then to B, so it created both the life estate and the future interest at the same time. So that rule is satisfied. The third rule is that the remainder mustn't have the ability to cut short the prior estate. And in this example, there's no way that B can get possession of the land until A dies, so B's future interest waits patiently for the prior life estate to end, and that rule is satisfied. The fourth rule is there mustn't be a built-in time gap between the prior life estate and the remainder, and here there is no time gap. It says to A for life and then to B. Well, then implies that B gets it immediately and instantaneously upon the end of A's life. So all four rules for remainders are satisfied, and our conclusion is that B does indeed have a remainder. Now we're going to look at some examples in which the future interest isn't a remainder, and I want you, as we look at each one, to say which of the rules for remainders does this one not satisfy so that it's not a remainder. In the first example, O, the grantor, conveys to A so long as the land is used as a residence, and then to B. You'll notice it doesn't say to A for life. It says to A so long as the land is used as a residence, and what that means is that what A has is not a life estate, but rather a defeasible fee estate, and B's interest is following a defeasible fee rather than a life estate, and therefore it can't be a remainder. It must be an executory interest. By the way, this fits with what we learned earlier about defeasible fee estates. What do we call A's interest here? It's defeasible, but to be more specific, it's a fee simple subject to executory interest. Why? Because B has the executory interest. So you see this fits with what we learned earlier about defeasible fee estates. In the second example, the grantor conveys to A for life and says nothing more. That means that the grantor O will have a reversion, and O will expect to take possession when A dies. However, while A is still alive, O gives a deed to B at a later time. That means that O is transferring inter vivos O's future interest to B. Can O do that? Well, in general, most states today will allow the conveyance inter vivos of any kind of future interest. And so the reversion that O originally had is now being transferred to B by that deed. It doesn't change its name because it's being transferred, and now the reversion is in B rather than O. So it's not a remainder, it's a reversion. In the third example, to A for life, but if and when A dies or fails the bar exam, then to B. Now B has a future interest all right, but you'll notice that it has the capability of potentially cutting short A's life estate. That would happen if A fails the bar examination. And anytime a future interest in the third party has the capacity to cut short the prior life estate, that means it violates the rule for remainders and it can't be a remainder, so what B has is an executory interest instead. Let's try some additional examples. This one says that O conveys to A for life and 1 year after A's death to B. Well, you'll notice that in this one there is certain to be a gap between the end of A's life and the beginning of the future interest in B. B doesn't get possession for a year after A dies. So there's a built-in time gap between the end of the life estate and the beginning of the future interest, and that means it can't be a remainder because one of the rules for remainders is you mustn't have a built-in time gap between the present and the future interest. So this one in B isn't a remainder, it's an executory interest instead. Here's another example that has a built-in time gap, but perhaps it's not so obvious. It says to A for life, and after A's estate has been probated, to B. Well, I don't know how long it will take to get A's estate probated, but it won't happen instantaneously, that's for sure. Chances are it will take at least a few weeks and more likely several months or possibly even a year or more. But the point is that there is a built-in time gap between the end of the life estate and the beginning of the future interest, and therefore B's estate cannot be a remainder. It must be an executory interest instead. Now here's a third one, to A for life, then to B when B graduates from college. Well, is there a built-in time gap there? There might be a time gap because B might not graduate until after A dies. On the other hand, B might graduate before A dies, in which case B is eligible to get the remainder as soon as A dies. In this example, there might or might not be a time gap, and we don't call that a built-in time gap. It's one that's not certain to occur, and therefore it's perfectly okay to call B's future interest a remainder. It doesn't break the built-in time gap rule. Now that we've taken a close look at the rules for remainders, we need to understand a little more about the nature of remainders. There are two kinds of them. They are called vested and contingent, and we need to be able to tell the difference between them. The difference is this: a remainder is contingent if either of the following two things is true. Either there's an expressed condition precedent, you could say precedent or precedent, either one is fine, and by a condition precedent we mean an if clause, a clause that says somebody gets the remainder only if something happens. Alternatively, a remainder can be contingent if the taker of the remainder is unascertainable. That is, we can't point to a living individual and say, you are the owner of this remainder. So either of these situations, either an expressed condition precedent or an unascertainable taker, will make the remainder contingent. We'll do some examples of each type. On the previous slide, we learned that one of the ways a remainder can be contingent is if there is a condition precedent, an if clause on the remainder. So let's take a look at this example. To A for life, then to B if B has passed the bar exam when A dies. Well, the if clause there is a condition precedent. It says B gets the remainder only if something happens. And because of that, B has a contingent remainder because it is subject to a condition precedent. Now you might ask yourself, well, that's very interesting, but who cares whether a remainder is vested or contingent? And there was a time back at the common law and in America until fairly recently when there were a number of reasons that we needed to classify remainders as vested or contingent. But most of those reasons have been done away with. Most of the rules that depended upon a remainder being vested or contingent have been repealed. And so there's really only one significant reason that we care whether a remainder is vested or contingent, and that's because of the rule against perpetuities. Now we have a separate video that we're going to use to cover the rule against perpetuities, so you don't need to worry about it right now. But suffice to say that the only practical reason that we need to classify remainders as vested or contingent today in most states is that contingent remainders are subject to the rule against perpetuities, vested remainders are not. Now here's another example to help us distinguish between vested and contingent remainders. This one, the grantor says to A for life, then to B's firstborn daughter. Let's assume that B has no daughters at the time this gift is made. There's nobody that we can point to and say, you are the firstborn daughter and you hold the remainder. So the taker of the remainder is unascertainable. There's no living person that we can say owns the remainder right now, and that's enough to make the remainder a contingent remainder, the fact that the taker is unascertainable. Now suppose that B has a daughter. Now there is a person. We can point to that person and say, you are B's firstborn daughter, so now the remainder's taker is unascertainable, and the remainder becomes a vested remainder. This is quite interesting, because what we've seen is that a remainder might start out being contingent. It might be contingent for a while, Then something might happen to make it a vested remainder, and it will be a vested remainder for a while, and then the prior life estate will come to an end by the death of the life tenant, and then and only then does the remainder become a possessory present interest. Here's another example of an unascertainable taker, but one that's perhaps not so obvious. It says to A for life, then to the heirs of B. Well, let's assume that B is a living person. Who are B's heirs? Now remind yourself of what the word heirs means. Heirs means the people who will take your real estate if you die without a will, if you die intestate. But the heirs are determined by a statute, and the statute refers to the people who are living when you die. But of course, if you're still alive, no one can tell which of your relatives will outlive you, and therefore which ones will become your heirs. When can we determine who B's heirs are? Only when B dies. So as long as B is a living person, the heirs are unascertainable, and therefore the remainder is a contingent remainder because those takers are unascertainable. Now let's suppose that while A is still living, B dies. Now we can determine who B's heirs are. We'll look at his family, see which of his relatives outlive him, compare that with the statute on heirs, and we can determine who his heirs are. So the heirs of B become ascertainable when B dies, and therefore the remainder becomes a vested remainder at that point. Notice that A is still living, so we're not ready to give the remainder to the persons who hold it yet. But the remainder started out being contingent, then it became a vested remainder, and finally, when A dies, it will become a present possessory estate. Now let's consider what happens if a contingent remainder is not ready to take when the prior estate terminates. Here's an example of how that could happen. The grantor conveys to A for life, then to B when B passes the bar. Now it's possible that B will pass the bar before A dies, in which case the moment of A's death, B is entitled to possession of the land. But it's also possible that B won't pass the bar before A dies, but might pass the bar at a later time. So what do we call this? The common law considered that the remainder was destroyed if it wasn't ready to take when the prior life estate ended, and therefore the grantor would have a reversion in fee simple absolute. But that's a rather cruel rule from B's point of view, and today the destructibility doctrine is no longer followed in most states. So what that means, of course, is that B's future interest is still perfectly good, even though B hasn't qualified to take the property at the time of A's death. So what will we do with the estate after A dies if B isn't ready to take it yet? Well, obviously, it's going to go back to the grantor, and we'd say the grantor has a reversion. And if we followed the destructibility doctrine, we'd say the grantor had a reversion in fee simple absolute. But in this case, because destructibility is no longer followed in most states, we'd say that the grantor has a reversion, but it's a sort of a temporary reversion. It will only last until B passes the bar. Now, B might not ever pass the bar, in which case when B dies, the grantor's reversion becomes a permanent possessory fee simple absolute. But since B is still living and B might pass the bar in the future, we might say that the grantor has a temporary reversion. Probably the best way to describe it is that the grantor has a reversion in fee simple absolute, except that instead of saying absolute, we ought to say it's a fee simple subject to executory interest. And that implies that B's interest is no longer a remainder, but is now an executory interest. Why? Because it's cutting short the prior fee simple that the grantor has. But this terminology is somewhat speculative. There's very little case law, one way or the other, to support it. Suffice to say that the grantor's reversion is a temporary one and might be cut off when and if B passes the bar exam. Now, we learned earlier that one of the ways that a remainder can be contingent is that there's an expressed condition precedent on the remainder's taking possession. A condition precedent is an if clause, and here are a couple of examples. To A for life, then to B if B has passed the bar, the one we talked about on the previous slide. Here's another, to A for life, then provided that B has graduated from college, to B. Now I put in the second one without using the word if. It says provided that instead of if. But don't worry about that. If the idea or concept is a condition precedent, you can express it in any words you want and it'll still be a condition precedent. So the second example, provided that B has graduated from college, is definitely a condition precedent, and B's remainder is a contingent remainder. Now, sometimes you'll find a clause that says somebody gets the remainder, but if something happens, they won't get it. If you find it in that form, it's not a condition precedent, it's a condition subsequent. In other words, if the language first gives the gift and then says, under certain conditions, it won't take after all, that's a but-if type of clause, and that makes it a condition subsequent. And if the remainder has a condition subsequent on it, then it's not classified as a contingent remainder, it's classified as vested, subject to defeasance. Now the difference is only grammatical. It's only in the way the condition is expressed. So it can be a little confusing, but just say to yourself, is it an if clause or is it a but-if clause? Here's an example at the bottom of the screen of a but-if type of clause that makes the remainder subject to defeasance, but vested. To A for life, then to B, but if B has failed the bar, to C instead. You'll notice that from B's point of view, this says B gets the property by way of remainder, but if something happens, namely B failing the bar, then B doesn't get it after all. That's a classic example of a condition subsequent, making B's remainder vested, subject to defeasance. We're going to review some of the principles that we've already covered by asking the following question. Why might a person who owns a future interest never actually get to possess and enjoy the property? There are 5 reasons that we're going to list why that might occur. Here's the first reason that a future interest might never be enjoyed by the person who owns it. The future interest owner might die before the future interest becomes possessory. Here's a pretty simple example of that. To A for life, then to B. B dies before A dies. Obviously, B never got to personally enjoy the remainder and possess the land. So who will enjoy the remainder? Well, the answer is it depends on who B leaves the remainder to. Remember that a remainder, even though it's a future interest, is perfectly divisible or descendable. In other words, it will pass to B's devosees if B dies leaving a will, or if B dies without a will, it will pass to B's heirs, and B's heirs or devosees are the people who will end up enjoying the remainder. They'll get possession of it when A dies. Here's the second reason that a future interest might never be enjoyed by the person who owns it. The owner might transfer the future interest inter vivos to somebody else before it becomes possessory. Inter vivos, remember, means during lifetime. So here's an example. A for life, then to B, and B, who holds the remainder here, delivers a deed to X before A dies. Now B is transferring by that deed to X B's future interest. Is it possible to transfer a future interest even though it isn't possessory yet? Well, the great majority rule in the United States is yes, it's perfectly possible to do that. So who will enjoy the remainder? Obviously, X has received the remainder by virtue of that deed. X is B's grantee, and X is the person who will actually get possession of the land when A dies. Another reason that a future interest might never be enjoyed by the person who owns it is that the future interest might fail. Now, the concept of failing is an important one and one that you really need to understand. Here's an example. To A for life, then to B if B has gotten married by the time of A's death. Well, B, let us stipulate, has not gotten married by the time of A's death. So what happens to the remainder? Well, the answer is it fails. By failing, what we mean is simply that it has become logically impossible for the remainder to take in possession. So who will enjoy the remainder? The answer is nobody. The remainder ceases to exist, and now all we have left is to A for life. So at A's death, the grantor will have a reversion in fee simple absolute. Remember, to fail means that, usually because a condition of the remainder has not been fulfilled, it's logically impossible for the future interest to become possessory. We'll do some more examples of future interests that fail, and as we look at each one, ask yourself, under what conditions can B's future interest fail? In the first example, O deeds to A for life, then to B if B has passed the bar exam by the time A dies. Well, let's assume that A dies and B has not yet passed the bar exam. In that situation, it's impossible for the future interest condition, the condition precedent, to be satisfied, and therefore B's future interest will fail. It's logically impossible for B to qualify to take the property later in time. In the next example, it's a little different, to A for life, then to B if B ever passes the bar exam. Now, if B hasn't passed the bar by the time A dies, it's still possible that B will pass the bar exam in the future and be entitled to possession of the land. So as we talked about before, there will be a temporary reversion in the grantor if that occurs. So B's future interest won't fail in that situation. However, it is possible for B's future interest to fail. Let's suppose that B dies while A is still living, and B dies without ever passing the bar. Now it's logically impossible for B to satisfy the condition because you can't take the bar exam when you're dead. Therefore, the future interest in B will fail if B dies without ever passing the bar exam. In the next example, O deeds to A for life, then to B for life. Well, B's future interest is only for life. It's not in fee simple absolute, and therefore, if B dies before A does, it's impossible for B to ever take the property. The life estate in B will, in effect, have ended before it began. Therefore, B's future interest will fail if B dies before A does. The final example is a little more complicated. O deeds to A for life, then to B, provided that B never enrolls in law school. And if B does so, then to C. Well, let's take a look at B's future interest here. B's future interest is conditioned upon B never enrolling in law school. And so if B does in fact enroll in law school, then B's future interest will fail, and B won't ever be entitled to possess the property. It doesn't matter whether B stays in law school or graduates from law school, the very act of enrolling will cause B's future interest to fail. Now you'll notice that C's future interest is sort of the opposite of B's. C's future interest will take possession only if B does enroll in law school, and so that means that if B dies without ever enrolling in law school, C's future interest will fail because it's logically impossible for C to ever take the property in those circumstances. Now I want you to notice the difference between these two examples. They seem very similar, but they're completely different. To A for life, then to B, and to A for life, then to B if B outlives A. You'll notice that in the first example, there is no condition precedent on B's remainder. So if B dies before A does, that doesn't affect the validity of B's remainder in the slightest. There's no condition precedent. B's remainder is perfectly valid. It will pass to B's successors, B's grantees, heirs, or devisees, depending on what B does with the property before death or when B dies, but the remainder is still perfectly good. Whoever receives the remainder from B will take possession when A dies. In the second example, however, there's a condition on B's future interest. B's future interest will fail if B dies before A does, because there's a condition that B has to outlive A. And so the grantor's reversion will become possessory if the condition precedent isn't satisfied and the remainder fails. Now, the point of all of this is we don't read in a condition of survivorship if there isn't one. In example number 1, it doesn't say if B outlives A, and we don't infer that, we don't read it in, we don't put in a condition of survivorship or survival if the grantor didn't expressly mention it. Now you'll remember that we were listing the ways in which a future interest might never be enjoyed by the person who owns it and thinking about why that might happen. The last of the examples of that is that it might violate some common law rule, but most of the common law rules that future interests might violate have now become obsolete. I'll mention the names of 3 of them. We've already mentioned one before. The rule in Shelley's case, the doctrine of worthier title, and the doctrine of destructibility of contingent remainders, which we did mention earlier. All of those are interesting if you like history, but they don't have any real relevance to modern law practice at all, and so it really isn't worth our time to go into the details of them. The final of the old common law rules is one that is still relevant today, and that's the rule against perpetuities. It can be quite important. It can also be quite challenging to understand, and so we'll have a separate video on the rule against perpetuities. Well, that winds up video number 9 on remainders and executory interests. Video 10 will be about class gifts. Those are special kinds of remainders and executory interests that are given to groups of people. If you have questions or comments, email profdale01@gmail.com. Thanks for watching.